All right, we're back. Gary, we're going to have Eric from Ledge Council start the walkthrough for the miscellaneous bill. Once Senator Matos goes up, we'll vote on S12. So, Eric, take it away.
Yeah, thank you, Senator Sheen. Good morning, Eric Fitzpatrick with the Office of Legislative Counsel. Here to start the walkthrough of the annual Judiciary miscellaneous bill. I'm sure as the committee members recall, this is something that's done every year to put together a number of provisions that sometimes are purely technical, sometimes are minor substantive provisions, but often don't seem to really warrant the time and sort of devote the resources necessary to make it their own separate bill. So we try and put them into this miscellaneous bill, as do many other committees in the legislature. I'm sure as everyone knows, it's a very common thing that we've done throughout the legislative process. So also the bill each year rotates where it starts. It started in the House last year, so it's starting down here in the Senate this year. So with that said, I'll just proceed right through and I'll try and some of these provisions are more quick and technical than others, but I'll give you a moment of background on each one so you have a sense of where it is. And also I try to mention where they came from there. Sometimes they're noticed by our office, sometimes they're suggested by other people. For example, section 1 on page 1. That was a request from Willa Farrell, the Community Justice Director of the Diversion Program at the Attorney General's Office. This is just a couple of technical changes. You'll see line 14, just inserting the word available to make it clear that diversion is available in all counties. They didn't want there to be any ambiguity about that. Doesn't change the law in any way, but just making clear that the program is available in all counties in Vermont. A couple more technical changes from Willett in the diversion program on page 2. Yes. Might finish that sentence?
Oh, yeah.
Section 2. So those technical, top of page 2, line 1, that's the common language that the diversion program needs. They don't say responsible party, they say person referred to the program. That's their terminology. And then line 18 is just a typo, a couple of stray words. If you read that sentence, you would say for some all those words of the must be a typo, and you'd be correct. So we're striking those. And that's it for section 1.
Thank you.
Yes.
Now that we have Senator Matos here, we can do a vote on S12 and then we can resume the walk through the miscellaneous bill. Senator Matos, we just went over some minor changes to the language and just make clear some definitions. Are you good to vote on it?
Yeah, I was listening.
Okay,
Listening on the way. I'm good.
All right, so I would entertain a motion to vote this out favorably. Senators.
So moved.
So, Senator Matos, please call. Oh, wait, sorry. Any further discussion? Before we vote? No. Okay. Please call.
Senator Norris.
Yes.
Senator Vyhovsky.
No.
Senator Baruch.
Yes.
Senator Matos. Yes. Senator Hashim.
Yes.
4-1-0. Do we have
So-
a reporter of the bill?
Presumably myself, unless there's somebody who has a burning desire for that. So, yeah, I'll report it. We are getting
I'm not gonna argue.
clean copy printed here and I'll run it up before I have to head off and then.
I do just want to say again, that this has been 5 years in the making. Crash and burn, crash and burn, crash and burn, crash and burn. It is an achievement of sorts to get a bill out with the language that we do. So.
Oh, I would agree. We'll see if there's any crashing and burning like this.
To the house.
But, yeah, and I'm sure we'll also end up revisiting it every other year.
Yeah.
Forever, but that's okay, great. Thank you all. And thank you all for your hard work on this. It's a lot. So yes, we can go back to the miscellaneous bill and thank you, Eric, for the pause there for that section 2.
Sure, no problem. And I just can't, referring to there was a pause in legal parlance, that's known as whole statute of limitations in the written saying it because there's a section in the bill of this. When the statute of limitations is temporarily paused, The legal term that's where it's used is toll. The limitation is toll. Some toll, like come up to a toll. Something can't come up to a toll. Yeah.
I said toll.
Well, the past tense.
Toll.
Yes.
Yeah.
Okay.
I thought you said toll.
Wait,
Oh, toll is like a cross.
TOLLED?
TOLLED.
I thought you said,
All right.
I'm just,
Yeah,
Sorry. They think it's kind of like a pause. You have to pause at a toll, and then you can start going after. Similar.
there's no pain.
All right, so that you'll remember that when we get to the toll section, which is further along in the bill. But before that, we're back to section 2, and as I mentioned, many of frequently these requests come from different groups, and sometimes they'll send an email to our office or to the legislator. One user said, "Hey, we got a few items. Might they be appropriate for the miscellaneous bill?" This section 2 was in an email that came from the judiciary, and you'll see several items in here as we go through this. This is a request from the court, and the change here, they're actually over on page 3. Under current law, there's a specified number of superior judges, line 1, page 3, and that number is 34. Now, that number changes sometimes, right? There are times when judges are added. The legislature has to, can do that and has done it sometimes. And when you do that, you have to change that number, 34. So the proposal here from the court is rather than going back and have to change that number every time you change the number of judges, you just say, that the number of superior judges this applies to shall be as determined by the General Assembly. So you guys, so that doesn't change the law. All you do is you have to determine what that number is now. And then the rest of the sentence is exactly the same. It doesn't change the term of office of the judges. It's still as it is in current law. That's no changes made to that. So the result of that is just that if the number of I don't know if that will
I have to run to the clerk's office, so I guess I'll find out in a moment.
All right. So, yeah, the result of that is that when in the future, the General Assembly decides to change the number of superior judges, you don't have to change it. They change the number to what it is that we think it should be.
So is that just section law then?
No, this would go right in the statute. That's the
Every time
when you change when you change the number.
Yeah.
Yes, that usually is in the budget. Exactly. Section 3 is also from the judiciary. This is just provides in the Judicial Bureau statute, the Judicial Bureau jurisdiction. There's a lengthy list. I think there's 37 now items that are within the jurisdiction of the Judicial Bureau. And when the statute is written and we add something to the Judicial Bureau's jurisdiction, we always add a few words describing what that type of case is. And this request from the judiciary, well, the description that you have with respect to minors possessing tobacco products isn't fully accurate, because the statute prohibits not only minors possessing tobacco products, but it's also procurement, in other words, purchasing or obtaining them as well. So that's just changing, doesn't change the law, it's just the description of the underlying Judicial Bureau statute in Title 7 that the Judicial Bureau has jurisdiction over. So that the description is more accurate. Section 4. This is also from the judiciary. So these several in a row here were requested by the court. This is under current law. A law enforcement officer can void a Judicial Bureau complaint. Right. So if you think about it, for a traffic ticket, for example, is one example of Judicial Bureau offense. Law enforcement officer fills out the ticket, fills out the Judicial Bureau complaint. Current law provides the LEO with the authority to void it. So before returning it to the Judicial Bureau, they can void it, and they can even do that afterward too. This is just making clear that that isn't an unrestricted, unfettered authority to void a complaint under any circumstance. Just saying that, well, unless there's some other provision of law that may say, maybe it's a regulatory law, something of that nature. It could be a constitutional principle that applies. If there's some other legal reason that the law enforcement officer can't void the complaint, then they would not be permitted to do so. So that's the idea, is just making sure that it's not, the language wouldn't be misinterpreted to say that under all circumstances and subject to no legal authority, the LEO can void it. And that's why it's page 3 and page 1. Continuing on the same topic over on page 4, section 5. There's just a technical change at first, just a gender pronoun correction. But the second one within section 5 has to do with also the Judicial Bureau offense related to tobacco products, in this case, minor presenting false ID to purchase a tobacco product, that under current law is a civil offense. It's not a criminal offense. It's only a civil ticket. But there's a misuse of a term in that statute, line 8, page 4, that says the person shall be fined not more than $50. Fined is the term that's used for a criminal, not a civil. So when a statute is drafted for a Judiciary Bureau offense, it doesn't use the word fine. You see the phrase that's there, but it is subject to a civil penalty of. So civil penalty and fine, two different things. Civil penalty, civil offense, Judiciary Bureau, fine, and criminal. So that's corrected to reflect that this is a civil offense, not a criminal. Excuse me. All right. So section 6, this one was a request from the Victims' Compensation Board. And this, the Victims' Compensation Board provides compensation to victims of crime. So they can file an application with the board, and if the board determines that they are a victim, in other words, they're a person who suffered a pecuniary loss as a result of a crime, then the Victims' Compensation Board can award them compensation. I think it's up to $10,000 per offense. But in addition to the actual victim, there's also a provision. This is line 15 at page 4. An intervener can also apply for compensation. An intervener is someone who is injured or killed in an attempt to assist the victim. See that? So someone else sort of jumps in and tries to help, essentially. The way it's phrased now, though, the intervener can get compensation for being injured or killed. And my understanding is that the Victims' Compensation Board there's been sort of a number of requests for when a person wasn't actually physically injured. And so this is making clear that an intervener, yes, they can apply for compensation, but there has to be a physical injury in order for them to do that. Moving on then over to page 5, section 7. This is purely technical. This is something that our office noticed every summer and fall. We engaged in what's known as a statutory revision process. We review all the acts that were passed by the legislature in the previous year. We work with our publisher, Lexis, down in Virginia, and we have to incorporate all those statutes supplements. And while we're doing that, we have to review everything, and sometimes we'll come across technical errors. And that's one right there, line 8, page 5. That's an unneeded subheading. We only use subheadings if every subsection has a subheading, or every subsection cannot have one. But we're not going to use them for one subsection if the other ones don't. For some reason, that's one subsection in a larger statute that was sort of a sore thumb. It had a subheading and none of the other subsections did. So technically it shouldn't be there, so it's struck. All right, section 8. This has to do with orders against stalking. That's an order that someone can go to the Civil Division Superior Court and get an order that someone to stop stalking, to be free from stalking by another person. Similar to, and this is related to, a couple of years ago in the miscellaneous bill, 2023, he made a change to, there's a similar relief from abuse order provision that allows someone to go to court and get an RFA. The relief from abuse order, the court orders another person to stop abusing and perhaps stay away from another person. There's all kinds of elements that can be in the order, but they get an order essentially that's directing those persons to cease the abuse. Now, the way that you may remember the change that was made a couple of years ago, if the defendant is in the court room at the hearing during the relief from abuse order hearing, the defendant is there, physically there, and the order is issued, and they get notice of the hearing by being there physically present. What the legislature did was you enacted a change that said, in that case, we're not going to require the sheriff to go out after the hearing, physically serve the person, even when they were physically there and heard about it in the first place. Instead, you said, all right, if they're there, they're going to be deemed to have gotten notice when they were sitting there. And instead of having the sheriff have to serve the person, it's going to be okay to just mail the order to them by first class mail. So that was the change that was made with respect to relief from abuse orders. This makes the exact same change for stalking, verbatim. So it's identical. It just strikes that sentence, bottom of page 5. It says, even if the court has previously notified the defendant, they still have to have the order served. And you add a new sentence on page 6. It says, in this case, you just have to send it to them with their last name.
Senator Norris. Yeah, that's right.
Yeah, I don't have a problem with this, Eric. My question is, the defendant If the defendant is in court.
Yeah.
Won't they simply give him or her the order then?
Yeah, I think they might. I wouldn't be surprised. I'm not sure exactly how that works in practice, but that's a good question.
Or
Maybe they
send
would.
it to a mailing address, the last known and just sits in perpetuity. So, okay,
Right,
at this
right.
point, all right, thanks.
No, it's a good question for the practitioners or for Judge Zone, who I think might be in next week with a couple of other proposals. I should have mentioned that there are a couple of other pieces to this that came in late this week. So we're still working on them, and they're going to come in as proposals next week. At least a couple I'm thinking of are for Judge Zone and Judiciary. So in any event, that might be a good question for the time. It's a good point. So maybe they wouldn't even need that last sentence. In other words, I think you're getting right. Why mail it out? They get it.
One way or the other, but
Right. Maybe they wouldn't take it. I don't know. It's guessing, but we'll see. All right. So that brings us to section 9. This purely technical, just an incorrect cross-reference that an attorney a practicing attorney brought that to the attention of our office, that there was a cross-reference to a statute that's wrong. You see that it changed the reference from A17 to A18, which is correct. Now we're moving on to section 10. This is another issue that was brought to our attention by a practicing attorney. Actually, it was brought to Senator Chief's attention by a practicing attorney. And this involves a potential conflict between two statutes of limitations that apply to a claim that's brought against somebody who has died. So the claim is actually brought against the estate. So if you think about it, it would unfold in a situation where, like, say there's maybe a breach of contract claim against somebody that didn't fulfill a contract, or maybe it's a creditor claim against the person. It might be an allegation that they owe a claim on a debt to somebody, or it could be a personal injury that the alleged person was involved in a car accident and I was injured. Someone brings a claim against it, but in the meantime, before that claim can move along, the person dies. So person passes away, then you have their estate. That claim could be brought against the estate after they passed away. Question is, how much time do you have to bring that claim against the estate? That's the issue. And it appears to be that there's two contradictory statutes on this. The one that you see in front of you, section 10, says if you look at page 6, line 20, you'll see the words there. These claims have to arise, they're barred, and now line 20, unless presented within 1 year after the decedent's death. So you have this one statute that says, okay, you can bring a claim like that, but you have to bring it within 1 year after the person passes away. Then you have another statute on the books that's in Title 12.
One second here. Senator Bohosky has a question.
I do have a question, and my question is, what if the person doesn't know the person's past? Like, what requirement is there? Like, what if the person doesn't know that someone died, and they discover that something happened, they want to bring a claim, and then, oh, too bad, they died 3 years ago?
That's an interesting question, and it may be that there's something that's known as the discovery rule, generally speaking, in statute of limitations law, and that generally says that you have to sort of know, not necessarily that you know that you have a claim, but generally you have to know about the facts and circumstances that would give rise to a claim, and until you know that, it kind of brings us back to the tolling question, in a way that the limitations period is told until you discover that you have a claim. And that's, I think, would kind of address the situation you brought up to the extent that if the person doesn't know that they have a claim yet, then it hasn't, then the clock doesn't start running, essentially, is the way it works.
Great, thanks.
Yeah. Although, still a question now, because as you'll see, and I was going to pass this out in case you want to see it, it's interesting. So there's a separate statute in Title 12, the General Statute of Limitations chapter. Thank you. And that provides something different about how long you have until to bring that claim against the estate. And this statute says, and this is Title 12, Section 557. It refers specifically to death of a party. And if you look at this is within a subchapter called Computation of Time, Tolling of a Statute. That brings us to the tolling issue, right? So what happens generally under this statute is, well, if you have a claim against the estate, When the person dies, the statute is told, which means remember to pause, right? That limitations period is paused at the moment that the person dies. And when does it start ticking again? According to this, it starts ticking again when the estate is opened. So when the person dies, limitations period told. Limitations period starts, the clock starts ticking again, tolling stops when the probate division opens an estate for the person. And then once the estate is open, you have 2 years from that moment to bring a claim. You see that's the last line of subsection A. After the issuance of letters testamentary, that means after the estate is open, the claim may be commenced by or against the executor within 2 years and not after. So that's different than the first statute we looked at, right? That first one said it has to be 1 year after the death. This says no, after the person dies, it's told until the estate is open, and then you have 2 more years after that. Seems to be a conflict. So a practitioner brought this to Senator Hashim's attention. I have a proposed fix on page 7, lines 3 to 4. That may not do it. It's a complicated issue, so I emailed this proposal out to Judge Zone, who has circulated it amongst some probate division judges. I actually sent it to Judge Kilgore as well, trying to get some feedback as to, what's the thought on this apparent conflict and how might we address it. So we haven't heard back from those folks yet. So this is another place where there might be some changed language the week after town meeting. But at least that gives you a sense of what the issue is, the conflict that's trying to be resolved. That makes sense? Yes. Right. All right. So moving on then to section 11, page 7. This goes back to the judiciary's list of requests. This is from the court. This has to do with guardianship proceedings. When a guardianship proceeding, when someone wants to ask the court to establish a guardianship for a person, they have to file a petition to establish a guardianship. And the court then has to make a decision on the petition. They either grant it or they deny it. Under current law, if the court denies the petition, right, they say, no, we don't think this person needs a guardianship. And this is line 9 and 10 on page 7. What the court does is they dismiss the petition and seal the records of the proceeding. But the court says no, we dismiss it and we seal the records. What the proposal here is that the court would do that same thing if the person who filed the petition voluntarily withdraws. They take it back. If they withdraw their own petition, that's line 11, page 7. Well, then the court does the same thing. They dismiss it and they seal the records. That's the proposal. All right. Moving on. This is we're now going into the Uniform Power and Attorney statute. You may remember this was passed a couple years ago in 2023. There had been an older one on the books in 2023. You passed the revised Uniform Power of Attorney Act, and that UPOAA included a model form, a lengthy model form that people could use. They don't have to, but it's an option for people to use when they establish a power of attorney. And there was a typo in that form. It's a mistake. It's over on page 9. You'll see that if you look at lines 1 and 2 and lines 5 and 6, the model form included the same thing twice. Exactly the same thing. We're not sure how that happened, but inadvertently lines 5 and 6 repeated what was already in lines 1 and 2. The consent to the modification or termination of a non-charitable revocable trust. What was supposed to be in that second instance, lines 5 and 6, is now line 7. Create, amend, or change rights of survivor. So that was what was supposed to be in the language originally. For some reason, it got overwritten by a provision that had already been stated in the language at lines 1 and 2. So this just makes a technical fix, strikes the old repeated language and inserts the language that it's supposed to be. Last year, I was still also on the subject of trust and uniform acts. Last year, you may remember that we passed the Uniform Directed Trust Act, and that was establishing a new role that people could use when they establish a trust. A trust director, it's called. The Office of Trust Director, you see, is what it's called on line 5, page 10. This is just a technical fix. There was some language missing in that statute. You see in lines, each, there probably, I think 1, 2, 3, 4, 5 different places, lines 9 through 13. The word under is missing. It does appear for whatever reason in line 8. It's just when we're referring. Line 8, for example, says acceptance under section 701. And that same word should have been in each of the following subdivisions 2 through 6. So it's inserted there. This is something that the Budget Council office noticed during our short revision process, and the same thing is the case in section 14. Next, our office noticed there's an incorrect cross-reference. If you look over on the top of page 11, line 2, this is the reference to defacing a firearm serial number, a statute that was passed, I think, 2 years ago now. And when the statute was passed, the cross-reference wasn't updated. So that's what this language does on page 11. So the statute is actually at section 4026, not 4024. All right, now we're moving on to section 15, that's line 7. This is another request from Willa Farrell at the Attorney General's office. This has to do with Act 180, which passed last year. Remember the pre-charge and diversion statute that was enacted last year. It doesn't actually have an effective date until July 1st of this year, but it was passed last year. Now, it's related to that Act 180 had a provision in it that basically said that that pre-charge diversion is available. Actually, I'll read you the language. The juvenile diversion program may accept referrals pre-charge by law enforcement or prosecutors where a child or a youth has committed any criminal offense or delinquency. So that was in the act that you passed last year. So that's the substantive provision right there that allows juvenile diversion to accept these pre-charge referrals when a child has committed a delinquent act. So what you're looking at in front of you now is just truing up the delinquency statute with that substantive language that's already in Act 1. But where that true up happens is over on page 12, lines 6 and 7. So right now, in the juvenile statute, when a child is charged with a juvenile offense, they have to be offered a risk and need screen. They don't have to take it, but they have to be offered the opportunity to do a risk and need screening. And when they do decide to take it, this is lines 2 through 4 on page 12. When the child does decide to do a risk and need screening, the state's attorney has to consider the results in determining whether to file a charge. And next sentence, in lieu of filing a charge, state's attorney may refer a child directly to a youth appropriate community-based provider that has been approved by the department. So in other words, pre-charge referral, right? That's the exact same concept that I was just referring to. It was in Act 180 last year. And so all this does is it adds to their list of things that the state's attorney may refer the child directly to that pre-charge diversion program that was substantively established in Act 180 last year. The language is already in 180 that says, hey, they can take these cases. It was just never added to this list to make it clear that the SA, in addition to, look at line 7, in addition to a community justice center or a balanced and restorative justice program, they can also pre-charge refer them directly to diversion. Under 163. So that's chewing up the two statutes. All right, section 60. This is a request that's come in from the Vermont Bar Association property section, the Vermont Attorneys Title Company, and Vermont Bankers Association. I should say all three of those groups have agreed on the language, so everyone's okay with this. The issue here has to do with essentially title searches when property is sold. And now remember, when you sell property, you want to get insurance, title insurance, and insurance on sale. You have to have an attorney do, or somebody do a title search of the property and verify that the property, clean title can be passed from the seller to the buyer, right? So as you know, the property records in Vermont are generally kept in the town clerk's office, and they can be lengthy and go back many, many years. So it's not unusual for there to be missing documents or something that's misstated in a record that's in the chain of title or in property records. And so for that reason, Vermont has a statute on the books. So you can see the title on line 16, page 12. We have a statute on the books called Instruments Concerning Real Property Validity. And the concept of what's going on in this statute is that in a number of different situations and types of records, the statute says, all right, if you've got a record that's been has been in the land records for a certain number of years and nobody ever challenged it for that number of years, then it's going to be valid. It's going to be deemed valid. Even if later on you find some technical problem with it, that technically speaking, it might not comply, because sometimes, the legislature has over the years passed updated requirements for powers of attorney or mortgages, things like that. And something that's older that's on the books might have been out of compliance with that, but the law changed. So what the statute does is it validates some of these older documents that may technically be out of compliance with what the legal requirements are. Yeah. So there's something, see, there aren't any changes there in the first couple of pages. I only put that in there so that you could kind of see as an examples of what some of the current documents are that are covered by this concept. For example, page 12, line 17 or 18. This is the oldest provision in the statute. You don't use the term instrument of writing anymore, but that could be a deed, could be a contract. It's been on record in the office of the clerk in the proper town, line 18, for a period of 15 years, and there's a defect in it because it omitted to state consideration or was witnessed or acknowledged, whatever. But if it's been on the record for 15 years, then it's going to be valid. That's over on the top of page 13. That's just one example. Another one, you see line 8, page 13, a release, discharge, or assignment of mortgage by a commercial lender. That's been on the in the town records unchallenged for 3 years. That's line 14 for that one. It happens to be 3 years. Then that is validated after that period of time. It hadn't been challenged during that period. You have another one, bottom of page 13 over top page 14, a power of attorney made for the purpose of conveying, leasing, or mortgaging real property interests.
Senator Norris?
Just a quick question, Eric.
Yes.
Why the magic number of 3 years? There must be a reason for that versus 2 or 4.
I wonder that. I don't have an answer to that. They've sort of been enacted at different times over the years. Probably there might be an underlying reason for why sometimes it's 3, sometimes it's 15. If I had to speculate, I would speculate that 3 years is sometimes, it is, depending on the type of the claim, is sometimes a period of the statute of limitations. So maybe they figured, well, we're going to we'll have it be consistent with the limitations period for a claim. But that's speculation. I don't know for sure. Yeah. So this proposal is to add one more to this list. This starts on page 14, line 9. So generally speaking, you see the very first words, the very first phrase is notwithstanding section 305 of this title. And that's referring to Title 27, section 305, which provides that generally, in order to convey land through a power of attorney, the power of attorney has to be signed, acknowledged, and recorded in the town clerk's office in the land. See that? So generally, if you look at the very first sentence in section 305, 27 BSA 305 that just passed out. The deed or other conveyance of lands shall not be of any effect or admissible in evidence unless the POA is signed, acknowledged, and recorded in the office. Right. So that's generally true. So what subsection F says, well, notwithstanding the fact that generally speaking, this power of attorney is not going to be valid unless it's recorded. If it has been, see that a deed mortgage release executed for the purpose of conveying real estate by someone acting on another's behalf, right? Power of attorney acting on their behalf of attorney back for POA. And now I'm on lines 12 and 13. That has been recorded for at least 15 years in the land records where the real property is located shall be valid, even if no power of attorney authorizing and empowering the attorney back appears of record. So in other words, notwithstanding the section that, because the section I just passed out, generally, you got to have that POA recorded in the land records. It says, well, notwithstanding that, even if the POA is not recorded in the land records, if 15 years have passed, and within that 15 years, no one's challenged it, then it's going to be valid. Even the deed is valid, even though the power of attorney that the deed is referring to isn't there. And that could have been, from what I understand, sometimes, a long time ago, maybe the attorney forgot to record the power of attorney. They recorded the deed, but they didn't record the POA that the deed refers to. That's it.
Eric, just a general comment. I think if we could, since they're in the room, if we could get the Bar Association, the Banks Association, folks are available. I think the 12th, when we get back to testify at around 10:15. around 10:15 or so, just to provide a little more context. My first reaction is wondering if 15 years is a little too short, but yeah, just want to put that note out there, and then when we get back, we can let's get some more clarification and information about it.
Yeah, sure, absolutely. So we're just about actually finished, so I'm sorry.
Here's the general, is that kind of because of all the POAs that were used during COVID or transactions, because we weren't allowed to go to closings?
That's a good question. It may be that although I don't think they would actually, because the 15 years would have passed since then, right?
No, but I'm thinking like 2035.
Oh, right, down the road.
Yeah,
Yeah, that could be, that was,
because every transaction had a POA
right,
for probably 2 years.
yeah, I remember.
Yeah.
Yeah, that'd be a good question when you have your witness testimony, is that sort of in anticipation of that, perhaps? So section 17 is also a request from the judiciary. This is a technical change. You know that the position that's now referred to as the chief superior judge. Judge Zoning happens to hold that position now. It used to be Judge Grierson, it used to be Judge Davenport. That's the name of that position, chief superior judge. It used to be referred to as the administrative judge. We've gone through the statutes a couple of times and made that correction several times. Like whenever administrative judge appeared, we changed it to chief superior because that's a new title, but we missed one. You'll see page 15, line 10. So it's just changing the position title to be accurate. Section 18. This has to do with a report that was passed in 2023, a reporting requirement that the Dale and the Department of Mental Health were supposed to report on how the forensic facility that was going to be created was functioning after it was up and running. But it's not up and it's not happening, not yet anyway. So what this provision does is it repeals that reporting requirement. That's simple. I said, yeah, nothing to report on. There is no forensic facility. That's the proposal there. That brings us to the effective date section. Date generally takes effect on the passage. Section 1, that's the version program statute.
July 2nd?
I know, there's a reason for that. And the reason for that is that you made this diversion change, which related to pre-charge diversion, which was passed last year in Act 180, but it had a delayed effective date. And it's not going into effect until July 1st, 2025. So these technical changes that Willa asked for from the Attorney General's office, they can't go into effect before July 1st, 2025, because then they would be inadvertent. They would go out of effect again on July 1st when the previously enacted bill goes into effect. So the way to do that, technically, is you have the July 1st changes that from Act 180 last year go into effect on July 1st, and these technical changes then go into effect the next day, on July 2nd. So gravity,
Never seen that.
sleight of hand. Right.
Makes sense.
Yes, thanks.
Eric, there are, a couple of pieces that some of us want to add on to this bill. The two, for me, involve the recidivism bill, changing the definitions, or rather refining and clarifying the definitions of recidivism and desistance. I just forwarded you an email from Ben, who had a draft of that bill. I think it's been introduced, but I don't think it's on our wall yet. I'll follow up with that, but
Okay,
I just sent you that.
right.
And the other piece I wanted to talk about was also raised by the Bar Association, but involves private attorney access on Odyssey, elevated access. That means private attorneys who do criminal law being able to access criminal dockets that are not the ones that they are assigned to. Currently, defenders and private attorneys who contract with the public defenders have elevated access. But for some reason, private attorneys who also do criminal work do not have elevated access. They would otherwise have to access it in the hallway of the courthouse. Even though these are all public records, it's not sealed records or anything like that. It's the same thing, the same documents that anybody can access. But for some reason, private attorneys can't do that from their office. So that I think I forwarded that to you maybe.
Yes, you did, yeah, and I took a look at it and we were a little unclear on the language, not the concept, but the language.
Okay.
So I sent it to Bob Galini, who I think forwarded it along to some of the other interested parties, and they're working on the language.
Okay.
So the idea is to try and get the language squared away by one of the after talking.
Okay, awesome. Those were my two off the top of my head at the moment. I think there were some others, some other members.
Yes, I was, PIP programs,
Which one?
it's the FIT programs, the public, the deviation program. As a sunset of July 1, 2025.
Oh, I think I know you're there too. July 20, did you say?
2025, I believe,
Yeah.
July 1, 2025, as far as DOC, not being able to, take individuals.
Right.
So I like this to just be
Repeal the sunset?
Yeah.
Yep.
The other question that I had was on S6. What is it, utility, I'm sorry,
61, I think.
61, I'm sorry, 61 utility nights.
Oh, yeah.
AKA switchblades,
Yeah,
Utility, right? Opening utility.
yeah, there you go. Automatic open utility nights. Is that something that would fit into the miscellaneous?
that would be AO UK.
Sure. Yeah.
Then you have to explain it. Yeah.
Sure. In other words, I remember that I happened to be in here.
So it's all.
That the length of the knife or something like that.
2.5.
Yeah, I was just gonna say, I think the reason I'm okay with this being considered a technical change, this is a law that hasn't been touched since 1959. Their definition is unclear, or rather, there actually isn't even a definition of what a switchblade is. And so I think incorporating that into the bill is fine. That's my thought.
I was gonna bring up the same. Didn't know if it fits into it's a technical thing but you make a great point, 1959.
Yeah.
Good, I got that one too. There's also, I mentioned a couple that Judge Zone is working on as well, or actually not Judge Zone working on. Well, one of them is having to do with background checks for guardians. That was another one where the language, he sent the language. We looked at it, it didn't look like it was ready for prime time, and so they're back and looking at it, trying to see if they can get it cleared. There's a repeal date for the Coordinated Justice Reform Advisory Council. It's also a request from the court that will be in the next draft. And actually another one, a guardianship study committee. I might be in that next, that's also from the court. The language came in a little bit on the late side, so we're still working on it.
You said this is something that have to go to your institution? I'm sorry.
No, I'm just gonna have to check with Senator Harrison about the
The immigration program.
thing. I think it was fine.
It should be because in St. Albans, or and probably other places also, it's staffing, they're closing down. These programs aren't available, so the other thing is to bring them down to corrections. So we've been doing it for years and years and years, or I guess leave them on the bench and the other part, I don't know, it's the best situation. So it's something I would need to at least address.
Sure.
Senator Bohosky, did you have anything?
I had originally suggested that the miscellaneous bill might be a good place to shore up the Good Samaritan law to include reports to immigration. But I'm also happy to try to do that in a revamp of S44. I just initially before everything was on our wall, I had suggested the miscellaneous bill for that.
That might be best because I'm hoping to get S44 out. We're getting the walkthrough of the very condensed version today. And then I'm actually hoping to do a vote on it first thing when we get back, unless something wild happens. But if there's language for the Good Samaritan piece, would we, I mean, it's up to you, but would you like to send that to Eric to see if we can get that into this?
So I have a drafting request in, but I haven't seen language. This is a challenge across the board.
Yeah. Okay. Well.
Like, I don't know what to do about it. It's frankly challenging to get anything. Yeah, anyways.
Well, perhaps it'll come out during town meeting week, and if it does, maybe we can attach it to the miscellaneous bill and keep our fingers crossed.
You want me to check with? I'm assuming, I don't know for sure, that if the drafting request is in, it must have been assigned to somebody in our office. I don't know who off the top of my head. But do you want me to follow up and see kind of where it's at?
I can, if you'd like to, but I can also do it. Whatever makes the most sense and is easiest.
Right. Yeah, either way, it's fine with me too.
Okay. Yeah, if you'd like to, given that you're drafting the miscellaneous bill and that seems like where we might put it, that would be great.
All right, sounds good. We'll do.
Thanks, Eric.
You bet.
Committee, anything further on miscellaneous bill? There are things you want to add, take away, discuss?
How long discussed with the center, we're just mentioning here, I haven't seen anything on it.
Yeah.
Just emergency. Still on Zoom, so it should be a copy of the break.
Yeah, I don't think she has copies, but hopefully, you know, with Eric checking in on that, we can get see what it is. Hopefully over town meeting week, that'd be great. And then if we add it to the miscellaneous bill. And yeah, I think that's pretty much it. Anything else, Senator Matos?
No, I don't think so. For this time.
All right.
Just, I just ask a technical question, see what you want to do. But at this point, you can sign it out. You made the original request on our sheet, which could do it that way. So would you want to go ahead and introduce what we have so far as the bill and do the rest would be, say, as an amendment that the committee will consider?
Yes, I knew I was forgetting something. Yes, to the help, so authorizing introduction of it, then, yeah. Perfect. Sounds good. We'll make amendments.
Right.
Okay, all right, great. So we can take a 10-minute break and, you know, let me see if Rick come in,